May I please the court? I'm Mark Stopa, counsel for the appellants. I would request 5 minutes for rebuttal.
Very good, Mr. Stopa.
Your Honor, there are a few reasons why we submit that the final judgment of foreclosure entered at the summary judgment stage in this case should be reversed. I'd like to start with the plaintiff's standing to foreclose. This case is a little unusual in that the note here was payable to Community National Bank at Bartow, and there were no endorsements. So without an endorsement, it's clear that the plaintiff's holder theory fails right off the bat. The only theories that they pled were owner and holder, so they're proceeding on an owner concept based upon an assignment of mortgage. The problem, which I think jumps out, is that the assignment of mortgage is not executed by Community National Bank at Bartow, the original lender, but it is executed by the FDIC, purportedly as receiver for Community National Bank at Bartow. Now that assignment of mortgage reflects on its face that it is being executed based upon two different documents. One of them is a limited power of attorney, which within the body of the assignment purportedly gave the power to execute that document. And the second is a purchase and assumption agreement between those entities. Now, neither of those documents was in the record before this court. Neither of those documents was in the trial court. They were not summary judgment evidence upon which the plaintiff relied at all. So just that issue creates a fatal defect which should have precluded summary judgment under what has become a lengthy line of cases, both from this court and others. And those cases stand for the proposition, essentially, that when you have one entity that is purporting to execute an assignment or an endorsement on behalf of another in the foreclosure context, whether it's as FDIC or attorney in fact or successor by merger or formerly known as, when it's not the actual assignor or entity that needs to do the conveyance itself, but is being executed by someone else purportedly on its behalf, that the proof of that relationship or ability to sign between those two entities has to be established. That proposition of law began with the 5th District's decision in Figueroa, and it was then followed by the 5th District's case in Bonafide, the 4th District's case in Frost, and this court's decisions in both Buckingham and Arcuri. There are not any contrary cases from any DCAs, and so that line of cases clearly required that the plaintiff prove that the FDIC was actually the receiver for Community National Bank at Bartow, and in this context required that the limited power of attorney and purchase and assumption agreement actually be summary judgment evidence before the court.
Was there an objection to considering the assignment in the trial court?
Well, we don't have a transcript of the summary judgment proceeding, and that
raised in, sorry, I asked the question just as I started pouring water. Apologize for that. Was that raised in any response or objection to the affidavit or response to the motion for summary judgment?
The record doesn't reflect that, and that's what my opponent harps on in the answer brief. But I submit that that is not a determinative factor in this court's adjudication of this appeal, because this is not. And the way that I've distinguished this issue in my mind, and I feel like this is kind of deja vu with two of you, because Judge Lucas, you just recently wrote the Johnson decision that Judge Silberman, you were on that panel as well. The way that decision is written is how I have long reconciled in my mind the question that you're asking here, and that is, there's a difference in the summary judgment context when you're adjudicating an appeal of a summary judgment ruling. There's a difference between the sufficiency of the evidence as reflected in the record and whether there was an evidentiary objection to that evidence that was filed. And the former class of cases, class of arguments, is what this court reversed on in the Johnson decision. And that goes to, and that was a standing issue as well. Part of the reason why I led with this, simply that there was not sufficient summary judgment evidence on the issue of standing in that case. Submit that we had the same fact pattern here. There was not summary judgment evidence of standing because the reliance upon the assignment is not this is not an evidentiary issue. It's not like I'm now trying to argue this wasn't authenticated when it should have been, or that this is summary judgment evidence that the court shouldn't have considered for some reason. Right. I'm just simply saying they needed more stuff, right? There's a difference between saying, I'm not here saying this shouldn't have been considered for an evidentiary reason. I'm saying that there wasn't enough evidence. And that's the way this court came down in Johnson, which followed Houck, and this court's decision in Houck, the first one to rule on the issue, and Kamen as well. And so that's why I'm leading with this summary judgment issue, and why I submit that it's clearly dispositive of this appeal, is that there simply wasn't summary judgment evidence to show that the FDIC was actually able to execute this assignment as receiver for Community National Bank, and that this court's decisions in Arcuri and Buckingham, which followed the line of cases from Frost and Bonafide and Figueroa, are really just right on point in that regard. You just can't come in and say, well, this assignment gives us standing because we're listed as the assignee, when it's not even a conveyance from the assignor. It's someone purporting to convey on behalf of the assignor, and they just didn't prove the issue. Now, it may be that at a trial that they could prove that through a limited power of attorney or by introducing the purchase and assumption agreement, but the Frost decision, that dealt with an assignment, or excuse me, an endorsement, but that was a similar context. The endorsement actually had the FDIC in the endorsement as part of it, and that court held that there had to be proof of that relationship sufficient for that endorsement to mean anything. The Bonafide case specifically dealt with an assignment. That was a power of attorney assignment, what I call a power of attorney assignment, where the assignor didn't assign, but a different entity purportedly on behalf of the assignor assigned, and the Fifth District ruled that there had to be proof of that power of attorney relationship. Buckingham was a successor by merger endorsement where the note was payable to one entity, and a different entity came in and endorsed it purportedly as a successor by merger for the entity that it was payable to, and this court said they had to prove the successor by merger relationship. I think it's telling that my opponent, even though they put together a fine brief, couldn't cite any case law that's contrary to that proposition, that there's nothing they can present that supports the proposition that they can use this assignment to prove standing when it's predicated upon a limited power of attorney and purchase and assumption agreement that simply aren't here. And so that's why they so quickly turned to the preservation concept, and I understand Your Honor asked the same question as well, but following the Johnson decision and the distinction that I articulated between the admissibility of evidence and the sufficiency of the evidence for summary judgment, preservation simply doesn't help them. That argument simply doesn't help them, and that this court should follow the Arcuri, Buckingham, that line of cases, and reverse based on the insufficient evidence of standing. I'll note also, before I go on to other issues, that I think it's telling that my opponent resorts to an argument that they intended to transfer title, that there was some, this intent to transfer title. That was argued for the first time on appeal. That's not a pled theory. That's why I mentioned in the beginning they pled owner and holder. Holder, that theory was obviously dispelled by the absence of an endorsement, and the owner theory is obviously dispelled based on this assignment issue. Their motion, summary judgment motion, and pleadings weren't predicated upon this intent to transfer title theory, and the fact that they're now trying to resort to theories which were not litigated below as a basis to affirm, I submit also shows how their argument to affirm on this standing issue simply isn't one which is well taken. So that's the first reason why I submit that the court should reverse.
Is there any case, I don't recall this from the briefing in this case, is there any case with an assignment such as this where there's an underlying limited power of attorney that is referenced, where we have reversed on a summary judgment, in a summary judgment case for failure to provide the power of attorney?
The only case which reverses in an assignment context is Bonafide. The other four cases were...
Was Bonafide a trial issue?
That was a trial issue. That was a Fifth District case emanating from a trial. The other four...
The reason I ask the question is I have a recollection of cases that say an assignment that is regular on its face is sufficient evidence absent an adequate challenge to it. And so that's clearly not a quote from any case, but that's my vague recollection because I know we've dealt with this before. So does that impact the analysis in this case, Mr. Stofa?
I'd submit no, because I'd like to think I know these cases pretty well, and I don't think that there's any case which supports the proposition that in the summary judgment context or any other context that you can have an assignment that is not from the assignor but someone purporting to act on behalf of the assignor that is sufficient without more. All of the case, and that's why they don't cite any cases, every case in every context, whether it's trial or summary judgment, where someone is executing on behalf of someone else, there has to be proof of the on behalf of someone else in order for that.
But I do recall that some of the cases, the issue of whether the agent had authority was raised. And I don't recall, again, in the summary judgment context, a case that says an assignment that is otherwise regular on its face is ineffective for purposes of trial absent proof of the underlying agency.
Well, you're using a term regular on its face, which when I hear that term strike, what I think of is affidavits of service. I don't think of assignments of mortgage. I don't think there are any cases that talk about assignments of mortgage being regular on their face.
Maybe my interpretation of some of the cases.
But even if there were, I submit that this is not regular on its face because it's not executed by the assignor. On the face of the document, it's Federal Deposit Insurance Corporation as receiver for. And so that's not even, you can look at the document and just see, well, this isn't even a conveyance from the assignor at all. It's not even, it's worse than a lot of them, what you see where it's just in the signature block, where it's someone signing as attorney in fact. Here, the very definition of assignor is not the original lender, but it's FDIC as receiver for the original lender, which to me makes all the more reason why that has to be part of their summary judgment evidence to show.
The original note was tendered in this case?
It was tendered at the summary judgment hearing, yes. So, but that goes to a holder theory, and the holder theory fails because there weren't any endorsements. So, no matter how you slice it, to me, they can't get an affirmance on the standing issue. So I do want to talk about the paragraph 22 issue as well. We submit there was not competent substantial evidence to show that the default letter was actually mailed. There was no documentary evidence attached to the affidavit showing that it was mailed, such as a return receipt, a mailing log, anything like that. And there was no proof, nothing in the affidavit reflecting a routine practice of mailing. And the cases have now become legion, making clear that you have to have something like that in order to show that the letter was actually mailed, as opposed to a conclusory assertion that it was by someone who didn't actually do it themselves. Now, what my opponent relies upon in response to that is to point to conduct of the parties after the letter, in particular my clients attempting to make payments after the letter. And they seem to try to suggest that my clients trying to make payments after the letter is somehow conclusive proof that they actually received the letter. But that's simply not so. My clients have affidavits where they unequivocally say they didn't get the letter. There's no unequivocal proof that they did get the letter. And I would acknowledge that the making of payments after the date of the letter is arguably proof of receipt, but it's certainly not conclusive for summary judgment purposes. At the summary judgment stage, they had to conclusively prove the issue of mailing, and the fact that my clients were making payments afterwards supports two different possible inferences. One being that they got the letter and they were trying to fix the problem, and the other being that they didn't get the letter and that they were making payments irrespective of having not gotten the letter. And so at the summary